Hello, my name is Kathy Clark. I'm with the Lawyers Committee for Better Housing. We've been working with the State of Illinois Department of Human Rights to develop a variety of fair housing trainings and to get them up on the web for viewing in the future. Today, we're going to cover Fair Housing 101, directed at condo associations and cooperatives. As usual, when you are viewing something for training and educational purposes, it should not be considered legal advice, and you should consult an attorney if you need such advice. We're going to cover fair housing basics, definition, who's protected, what types of discrimination are covered under the law. We'll answer some questions. We'll have a special section on disability, including accessibility and reasonable accommodations and modifications. We'll talk about cases that have been brought against condos and condominiums, condos and cooperatives, and the cost that can often come with noncompliance with the Fair Housing Act. We'll talk about exemptions, some best practices that are recommended for condos and co-ops, why fair housing testing is an important component, and how complaints are filed. What is fair housing? Federal law defines fair housing as the right of all people to live wherever they choose, have access to seek, purchase, sell, lease, or rent, and enjoy the full use of their homes, without being discriminated against, without having unlawful interference, coercion, threats, or intimidation by owners, landlords, real estate agents, or any other persons. There are three types of discrimination: overt, differential treatment, and disparate impact. Overt consists of blatant unfair treatment of someone because of their membership in a protected class. Differential treatment is unfair treatment of one person compared to another because of their membership in a protected class. Disparate impact is a practice or policy that is applied uniformly but results in a discriminatory effect on a group of persons in a protected class. In addition, such a policy is not justified by a business necessity. Under the Fair Housing Act, which is the federal law, also known as Title VIII of the Civil Rights Act of 1968, which was later amended to include additional categories, it is illegal to discriminate against a person or group of persons under the following protected classes: race, color, national origin, which includes ancestry, and basically means where a person or their ancestors were born; religion, aspects relating to religious observance, practice, and belief; sex, including sexual harassment; status as a male or female. It also includes pregnancy-related allegations and cases dealing with sexual harassment; disability, both physical and mental; and familial status, which is defined as the presence of children in a family unit. In addition to the protected classes mentioned in the Fair Housing Act, the Illinois Human Rights Act prohibits discrimination based on the following: age 40 and over, ancestry, general ancestral background, for instance, Hispanic, European, etc., the legal status, being married, single, separated, divorced, or widowed; unfavorable military discharge, includes RE3 classification, but not RE4 or dishonorable discharge; military status, such as active duty, veteran, or member of reserves. Recent amendments to the state law include sexual orientation, which includes the actual or perceived heterosexuality, homosexuality, bisexuality, or gender-related identity, whether or not traditionally associated with a person's designated sex at birth. Also, order of protection status, which is the person's status of being protected by an order of protection issued pursuant to the Illinois Domestic Violence Act of 1986, or an order of protection issued by a court of another state. Note that Chicago, Cook County, and some other jurisdictions have additional protected classes. For example, Chicago protects source of income, including housing choice vouchers. Cook County also protects source of income, but excludes housing choice vouchers. Unlawful actions under fair housing laws. Expressing the intent to discriminate by placing ads or engaging in real estate transactions. That can include advertising agencies that produce the ads, publishers such as newspapers, directories, multiple listing services. It does not include internet listing services such as Craigslist. Another unlawful action would be misrepresenting the availability of property. This covers rental units and property listings that are residential. Refusing to engage in a real estate transaction. Refusing to accept or transmit a bona fide offer. Or refusing to accept an application, for instance. Other unlawful actions include altering the terms or conditions of a real estate transaction, such as charging someone a higher security deposit or rent amount based on their being in a protected class. Refusing to allow reasonable accommodations or modifications for people with disabilities, such as denying someone the right to build a ramp, refusing to hold meetings at a wheelchair accessible locations, etc. And we'll talk more about disabilities. Creating a hostile environment or unreasonably interfering with someone's use and enjoyment of their premises. This could include sexual harassment of tenants, having unreasonable rules and restrictions on children, such as not allowing them to use the pool or restricting the hours that they can use a pool or that they can't play outside. Having unreasonable occupancy standards could violate the Fair Housing Act. This would depend on the size and layout of the unit or other physical limitations of the property, but in general, 2 persons per bedroom is considered reasonable and can often be used to discriminate against families by reducing the number of persons per bedroom. It's important when you're looking at the number of people in a unit based on the number of people in a bedroom that you consider the total number of people that will be renting, not how many adults and how many children there are, but what is the total number of people. Segregating families or other groups of people to certain floors or buildings could be unlawful, and failing to comply with the Housing for Older Persons Act. We're going to ask and answer some specific questions related to condos and co-ops. First, must condo associations and cooperatives comply with fair housing laws? Yes. All members of a condo association or co-op are responsible for complying with fair housing laws and can be held liable for any violations. Fair housing laws cover all multifamily housing, regardless of ownership. Do fair housing laws supersede any bylaws, resolutions, or rules and regulations passed by condo associations or co-ops? Yes, fair housing laws are legal authority beyond the documents of a condo association or a cooperative. Therefore, all policies and rules of a condo or co-op must be written and applied in accordance with fair housing laws. Those who could be found liable for violations include boards of homeowners associations, individual property owners, and management companies. If found in violation of fair housing laws, significant penalties, including fines and monetary damages, may be assessed. Does a condo association or cooperative board have the right to choose who lives in their community? Yes, but not in a manner that violates fair housing laws. Condo, co-op, and homeowners associations often reserve the right to select or deny owners or tenants, using criteria based on valid business reasons such as acceptable credit history, minimum income, references, etc. This practice is legal as long as the criteria are applied equally to all applicants. And again, this is a requirement of boards, members, property managers, anyone who's responsible for making selections for the condo or co-op. There are specific provisions under the fair housing laws for individuals with disabilities. Design and construction requirements are laid out in the federal law, and there are 7 principles. All covered multiple family buildings must meet certain requirements. That includes buildings built after March 13th, 1991, consisting of 4 or more units that are ground level, or if all units in the building are in a building that has an elevator. Housing can be privately owned, federally or publicly assisting, including single-family homes if they are in 4 or more to a building, apartments, condos, dormitories, assisted living developments, time-sharing properties, and homeless shelters when used as a residence. So the requirements include the public and common use areas must be readily accessible to and usable by handicapped persons. All the doors designed to allow passage into and within all premises are sufficiently wide to allow passage by persons with disabilities in wheelchairs, and all premises within the building units contain the following features of adaptable design: an accessible route into and through the covered dwelling unit, light switches, electrical outlets, thermostats, and other environmental controls in accessible locations, reinforcements in bathroom walls to allow later installation of grab bars around the toilet, tub, shower stall, and shower seat where such facilities are provided, and usable kitchens and bathrooms such that an individual in a wheelchair can maneuver about the space. HUD has published a Fair Housing Accessibility Guideline booklet intended to provide a safe harbor for compliance with the accessibility requirements. Although these guidelines are not the only method of complying with the Act, they are the most commonly known and utilized by the industry. Reasonable accommodations are changes in rules, policies, practices, or services necessary to accommodate persons with disabilities, such as designating handicap parking, waiving a no pets rules for support animals, providing alternate methods for mail delivery, holding community meetings or events in locations that are accessible, and providing sign language interpreters for meetings if there are residents who are deaf. Reasonable modifications are structural changes so that a person with a disability can fully enjoy their home, such as installing a ramp for wheelchair access, installing sturdy grab bars in the bathroom, modifying the door tension, widening the doorways for wheelchair access, or installing a doorbell that activates a light instead of sound. Associations do not necessarily have to pay for reasonable modifications unless the building is out of compliance with the Fair Housing Act. Property owners and associations do need to maintain any modifications made in the common areas. For example, if a person with a disability pays to have a ramp installed in a common area where snow is routinely shoveled, the association has to have the snow shoveled off of the ramp as well. Permission to have a reasonable modification may be contingent on restoring the premises to its pre-modification condition except for normal wear and tear. This does not apply to modifications in common areas. The individual requiring or requesting the reasonable modification may be asked to pay into an escrow account in order to pay for restoring the premises to pre-modification condition. Condo associations and cooperative must reply to requests for reasonable accommodation or modification in a timely manner and are responsible for maintaining modifications made in common areas. When is a request reasonable? Well, a request may be unreasonable if it imposes an undue financial burden on the condo or co-op, if it imposes an undue administrative burden, if it fundamentally alters the nature of the operations, or puts others in the community in danger. Also, remember that it is unlawful to charge a pet deposit for service animals or require certification or training for service and support animals, or to ask people to give details about their actual or perceived disability or medical history. So the questions that a co-op or condo board needs to ask itself when it receives a request: would granting the request be too costly and an undue burden for management? Would granting the request put others in the community in any danger? These are balanced against the right of the person with a disability to enjoy their home in the same manner as other residents. If an association is found to have engaged in discriminatory conduct based on its reliance on the perceived duty to abide by the terms of their governing documents, the association may be exposed to liability for the attorney's fees of the plaintiff, in addition to its own legal costs and other penalties. A finding of a violation of the Fair Housing Act does not require a showing of discriminatory intent. This was established through court cases, in particular Travada versus the City of Manchester, New Hampshire. The site on that is 992 F Sup 493, New Hampshire, 1997. An innocent attempt to enforce the covenants of an association can easily cause a board to place their association in harm's way. Being found liable for violating the Fair Housing Act can be very costly, particularly for condominiums and co-ops. Illegally failing to provide a reasonable accommodation or modification. For instance, here are some examples of cases where condos or co-ops have been sued and been found liable. In 2004, it cost the Glenview Condo Association $85,000, and they were required to allow a resident using a wheelchair to enter the building in a main entrance as opposed to a rear entrance, which they had been requiring. In 2012, a condominium association in Puerto Rico refused to repair inoperative elevators in an 11-floor building, violating fair housing laws based on disability. Cost, $1 million. Again, discriminating because you believe you have to abide by the terms of your governing documents, even if they violate the Fair Housing Act, can mean liability. In 2012, a Utah Condo Association was ordered to pay damages and adopt a new policy that removes fees and insurance requirements for service animals. Cost $20,000. In 2003, it cost an HOA and property management company in California $130,000 because they had prohibited children from playing in the common areas of a 56-unit townhouse complex. Additional cases include the Delray Beach Condo Association, which in 2006 refused to allow sale of a condo to a black family. That cost them $150,000. And the Latvian Tower Condo Association had to comply with the consent order, costing them $128,000, where they attempted to prevent sale of a unit to a family with children. That was in 2010. Additional questions and answers. Can condominium associations and cooperatives refuse to rent to people they perceive to be immigrants? No. Everyone should be allowed to rent or own wherever they choose and can afford to live. Denying housing to persons because of their actual or perceived race or national origin is illegal under the law. Fair housing laws cover all persons, regardless of their immigration status. Can board members or management ban holiday or religious symbols? No. Banning or requiring holiday or religious symbols can be considered discrimination based on religion. Religious proselytizing by board members or management can be considered harassment. There are exemptions for certain kinds of buildings. Senior housing. To qualify as senior housing, the housing must be intended and operated for occupancy by at least one person 55 years of age or older per unit, and must have at least 80% of the units occupied by at least one person who is 55 years of age or older, and establish and implement age verification procedures. The other way to be classified as senior housing is to restrict all persons in the building to age 62 or older. Religious organizations and private clubs are exempt. Owner-occupied buildings with 4 units or less, the so-called Mrs. Murphy exemption under the federal law, are exempt. Individuals who own 3 single-family homes or less for rental at any one time, but only if the home is sold or rented without the use of any advertising or real estate agents. This is under the federal fair housing law. It's advisable for condominiums and co-ops to follow best practices of operating their associations so that they don't run afoul of fair housing laws. Challenge stereotypes and learn about fair housing laws, disability accessibility, and diversity through training for staff and board. Promote integration and equal opportunity. Have your policies and practices in writing and apply them consistently to everyone who applies. Notify all owners and renters of the fair housing laws and where to report acts of discrimination. Have clear written guidelines in place to respond to requests for reasonable accommodations and modifications. Always maintain detailed documentation of incidents that might result in a complaint from a disgruntled applicant, owner, or renter. Be aware of discriminatory statements and/or pictures when advertising a unit. This means that if you do intend to use human models in your advertising, use diverse models as to race, family type, disability, etc. Be careful about using statements that would discourage certain categories of people from applying. For instance, perfect for a couple might discourage a family from applying, even if the unit were large enough for a family. Have reasonable and objective screening criteria available in written format, and keep records of all applications and actions taken. Fair housing testing. Testing is an approved method all the way up to the Supreme Court, actually, for enforcing fair housing laws, and it can occur in the rental, real estate sales, or lending markets. Without testing, housing discrimination often goes undetected. It is used to obtain evidence of any differential treatment based on an individual's protected class status. An organization conducting fair housing testing typically set up volunteers with similar profiles and housing needs, but with different protected class statuses, such as race or disability. The set of testers then would apply for the same available housing unit to see if they're treated differently because of their protected class status. Testing can occur on an audit basis, where fair housing agencies routinely test different entities within their service area, or it can be complaint-based, where someone perceives that they may be discriminated against, and testing is one way to determine whether or not discrimination was happening or whether it was just an unfortunate incident and not based on illegal discrimination. Other evidence that can be used as source of discrimination in a complaint: signs or ads, written or oral statements, disparate treatment such as a different down payment, different application fee, written documents that reveal discrimination, testimony of witnesses who have heard improper statements that are of a discriminatory nature, and so forth. Persons who wish to file a fair housing complaint have either a year or 2 years after the discriminatory conduct to file the complaint, depending on what forum they use. Under the Federal Fair Housing Act and the Illinois Human Rights Act, the complaint must be filed within 1 year. State court and U.S. federal courts allow 2 years. If a complaint is filed with an administrative agency, such as HUD or Illinois Department of Human Rights, the time that the complaint is at the administrative agency is tolled for purposes of filing in the U.S. federal or state courts. That means that that time is not included in calculating the 2-year filing period. Chicago and Cook County also have fair housing laws and accept complaints within their jurisdictions. What kind of relief is available? Make-whole damages are available under both the Federal Fair Housing Act and the Illinois Human Rights Act. The Federal Act also allows punitive damages, while the Illinois Human Rights Act does not, but it does include civil penalties. Federal Act can also levy fines. Both can provide injunctive relief. And in the case of a complainant who prevails, the guilty party may be liable, and most likely will be liable, for their attorney's fees and costs. The Human Rights Act allows for civil penalties of up to $10,000 to be awarded for a first offense. At the second offense, that goes up to $25,000, and the third offense up to $50,000. Fair housing complaints can be filed both with HUD in their Chicago regional office and with IDHR also in the Chicago office. Both of those entities will investigate a fair housing complaint and make a decision whether or not they believe there is enough cause to go forward with the hearing. HUD has a toll-free number at 800-669-9777 and a TTY number at 800-927-9275. Their webpage for further information is at www.hud.gov. The Illinois Department of Human Rights housing inquiries can go to phone number 312-814-6229. They can be reached by email at idhr.fairhousing@illinois.gov. Their toll-free number is 800-662-3942. Their TTY number is 866-740-3953. And their webpage for additional information is at www.illinois.gov/DHR. This is one of a number of trainings that are going to be available at this same site, and there are also a number of fair housing agencies funded by HUD that are also available for training and other information. In preparation of this particular training directed toward condominiums and co-ops, we would like to give special thanks to Jeffrey L. Tarrin of Condo, Tarrin, and Garrity PC in Chicago for sharing his ideas and training materials. Thank you.